Hello and welcome to Counseling Ethics, Lecture 18. My name is Dr. Amber Hughes. In this lecture, I want to talk about malpractice. Malpractice involves professional misconduct or unreasonable lack of skill. It can be defined as the failure to render professional services to the level expected in a particular community by a prudent member of the profession, with the result that a recipient of services is harmed. And so that professional in a particular community would be you, the counselor. Malpractice includes or involves intentional wrongdoing, incompetence, or unintentional wrongdoing. Okay, so it includes intentional wrongdoing, which would seem obvious, but also unintentional. So it's important that we understand what it is so that we can be careful to protect ourselves against it. Malpractice is a type of civil lawsuit filed against professionals for practicing in a manner that leads to injury to a recipient of their service. And on page 189 of the text, there's a list of elements that the plaintiff, who would be your client, must prove to win a suit against a counselor. There are two types of causes. First, there's proximate cause, whether the client would have been injured due to the action or inaction of the counselor. And then there's actual cause, which is when the client has been actually injured by the counselor. Reasons for most malpractice lawsuits include sexual relationships with clients. This would be actual cause. And clients attempting or completing suicide, and this would be proximate cause. Okay, so with the actual cause, again, the counselor is actually doing something to the client. So this would include a sexual relationship, which is not okay ethically. Now, the proximate cause is due to the inaction or action of the counselor. And so in the case of clients attempting or completing suicide, this would be when the client has failed to warn sufficiently or to report sufficiently instances of harm. And so this is where I'm going to talk a little bit about harm to self or others, which we've already talked about briefly. In terms of confidentiality or breaking confidentiality. But we also want to look at it in terms of malpractice, right? Because this is an instance when we can be sued because of action or inaction. So first of all, suicide is when a client threatens to commit suicide. A homicide is when a client threatens to harm someone. So you're going to have the threats in your office more often than not. And it's up to us as counselors to determine what level of threat that the client poses and what we should do about it. In either case, we have an ethical duty to protect the client from harm to self or others from harm by the client. Standard B2A of the Code of Ethics says that confidentiality requirements are waived when disclosure is necessary to protect clients or others from serious and foreseeable harm. Counselors must be prepared to take measures to prevent suicide attempts. These actions do break the client's confidentiality, though. And so according to Standard B2E, we should only disclose info to others considered essential to help prevent a suicide or homicidal attempt. So again, remember when we're breaking confidentiality, it's not like we're just spilling the beans and telling everything. We just release enough information to be pertinent and to be helpful in this duty to warn. Whenever someone threatens harm, whether it's suicide or homicide, we could complete a thorough risk assessment to determine how serious the client is in following through with their threat. We should involve the client's family or significant others when possible to support and aid them, and then arrange for voluntary hospitalization or involuntary commitment of the client once you've determined the level of harm. Now, we don't go to that level unless there's a very serious threat. Okay, so there's a lot of steps that you take whenever you're determining risk. And you only certainly go for involuntary commitment of the client when you feel that the threat is great. No matter where you work as a counselor, you are likely to provide services to individuals who might express suicidal or homicidal thoughts. Counselors can be held liable for overreacting and underreacting to client suicide or homicidal ideations. So it is imperative for the counselor to know the warning signs that indicate client risk for suicidal or homicidal actions. The law does not require that counselors always be correct in making their assessments of suicide and homicide risk. But professional obligations to a client and other potential victims in a manner comparable to what other reasonable counselors operating in a similar situation would have done. So again, it's not about perfection or about making the right determination, right? Because in these instances, we're trying to predict something that we can't do. And so it's important to follow the ethical decision-making process in these instances. It's important to document whenever possible and appropriate. And always consult. Now, Standard C23 advises counselors to consult with other mental health professionals when they have questions regarding their ethical obligations or professional practice. So our code of ethics says that we should consult. The counselor should document the steps they take in their assessment process or risk, regardless of the outcome of the risk. So whatever you determine, whether it's low or high risk, you want to make sure you document. And page 191 includes a list of essential items to include in the documentation of notes. When you make a decision that a client is a danger to self or others, you must take whatever steps are necessary to prevent the harm, and your actions must be the least intrusive to accomplish that result. This is where it's helpful to involve family in the process. Because sometimes notifying family is the least intrusive step to take. If you work in an agency, school, hospital, or other setting, you must always follow procedures established by your employer. And so I recommend whenever you start at a place, you find out the policy and procedure for suicide and harm assessments. Because sometimes it's very specific, and sometimes it involves bringing in outside organizations. So when I worked as a school counselor, we would do an initial assessment in our office, but then we would bring in an outside crisis team to make the determination. The final determination. And so some places will have contracts with outside organizations who provide that service. Established organizations often have specific protocols that helpers are required to follow. Some may or may not have guidelines, and so you want to make sure that if your place doesn't have a guideline, that you still have a plan in place. Situations in which the counselor must decide whether a particular client has the potential of harming another person or an individual's property is a little different. So this is the homicide or threat assessment versus the suicide. And so it's very similar but yet different because you're determining harm to others. A step you must take is to warn the intended victim. Okay, so in these instances, you're not worried about your client, you're worried about contacting someone else. So you're extending that break in confidentiality a little bit in these instances. And so you have to know who the intended victim is in order to warn them, right? Again, standard B2A states that counselors' confidentiality requirement does not apply when disclosure is required to protect clients or identified others from serious and foreseeable harm. Research indicates that predicting homicide is impossible, yet the counselor is required to determine if a client is dangerous. And so how do we do this? We should first know the warning signs of people who commit violent acts against others.
Mommy.
Be careful of depending on profiles. Just break time, people. All right, let's try this again. So we should be careful of depending on profiles because, again, they don't always fit. But generally, you follow the same guidelines that are listed in Figure 8.1 of the text. Special situations like domestic violence. Oh, gosh. Now the dog's chiming in. That didn't sound very good. Did it? Anyway, special situations like domestic violence require deviations from the general guidelines of signs and actions. Now, we do have a case that helps guide us in these situations. So the Tarasoff versus Regents of University of California case in 1976 tells us that the counselor does have a duty to warn an identifiable or foreseeable victim. It's a landmark case. This case established the legal concept in California. Although the Tarasoff doctrine has not been accepted or applied in every jurisdiction in the U.S., counselors have chosen to incorporate it into the ACA Code of Ethics in that standard B2A, and generally assume that the concept is a national legal requirement. Because of the Tarasoff case, when a counselor determines a client might harm an identifiable or foreseeable person, they must directly or indirectly warn that individual of the danger, except in Texas. Texas is the only state that rejected the Tarasoff duty to warn. And Texas counselors do not have a duty to warn intended victims if their clients threaten to harm another. If a mental health person in Texas did warn an intended victim, the professional might potentially be liable to the client who made the threat for breach of confidentiality. So, if you're in Texas, don't warn. And then we also have special instances when we have clients who have communicable diseases like AIDS or HIV. Do counselors have an ethical duty to warn when a client with confirmed HIV could be putting others at risk through unprotected sex or needle sharing? According to standard B2B, which speaks specifically to contagious and life-threatening diseases, when a client discloses they have a disease commonly known to be communicable and life-threatening, the counselor may be justified in disclosing information to identifiable third parties if they are known to be at serious and foreseeable risk of contracting the disease. In addition, it says, before making a disclosure, the counselor assesses the intent of the client to inform the third party about their disease. So you do some sort of like a type of risk assessment to determine if they are going to engage in that behavior. Counselors should adhere to relevant state laws concerning disclosure about disease status. Please note that the code says that counselors are justified in disclosing but not required, okay? So this is an instance where it's up to you to make that determination. Some possible steps for HIV positive case situations. The client must disclose that they are infected with HIV. Consulting with the client's physician is always a good option. Informing the physician of your concern may transfer the duty or obligation of protecting others to the physician. If the physician isn't an option, determine if the client has informed the third party. If not, then you must make the decision whether you want to break confidentiality and warn. Again, being aware of applicable state laws. According to standard C2E, if you are in doubt about whether you have a duty to warn, protect, or report in a given situation, always consult with fellow professionals or your professional organization's ethics and legal advice hotlines.